Okay, we are good to go. We are now being recorded on WebEx and are also live on YouTube.
All right, thank you. Let's get started. We have, I can see the Albany room, but not on the big screen. That's okay. There is a bit of a minor delay too, I believe, in the sound, so I will do my best to take a breath, believe it or not talk fast, and make sure if somebody has questions or comments that they can get in. But good morning, everyone.
Morning.
And welcome to the September 22nd, 2023 meeting of the New York State Commission on Forensic Science. Unfortunately, the Commissioner Rosado, is unable to be here with us today, and she's asked me to step in to chair the meeting. I apologize in advance. This week, I just want to take time to note, marks the 11th annual National Forensic Science Week. Very proud of that. We as a commission see the actions taken throughout the year by our accredited labs to maintain the highest quality standards and provide reliable forensic science services to the citizens of New York State. This year, we've seen many things, including after 22 years, the New York City Chief of Office of the Medical Examiner continues to identify victims from the attacks on September 11th. After more than a decade, the Suffolk County Crime Lab continued to work cold cases to help bring closure to victims and their families. And labs across our state continue to work diligently to provide the investigative leads to curb gun violence and the opioid epidemic. We continue to see progress with the latent print units moving towards becoming accredited. I just want to take a moment, please join me in thanking the 22 accredited labs and their staff and all they do each and every day for the citizens of New York State. Thank you all.
Thank you.
At this time, I'll take attendance to establish a quorum. As there are members joining both from New York City and Albany, will conduct business through roll call. Please respond present when I call on you. Dr. Bufalino?
Here.
Ms. Goldthwait?
Here.
Ms. Roush?
Present.
Dr. Chitlin?
Present.
Ms. DeCastro?
Present.
Dr. Marciano?
Present.
Ms. Schmitz?
Present.
Mr. Fitzpatrick?
Present.
Judge Mazzarelli?
Present.
And Dr. Willie?
Present.
We also have Superintendent Negrelli joining us online. You do not count towards quorum, sir. I apologize, and you cannot vote, but you are more than happy to participate in this wonderful meeting we have scheduled today.
Thank you very much. Good morning, everybody.
Morning.
Morning.
So, including myself, we have established a quorum. We'll start off with the review and the approval of the meeting agenda. You received an updated draft agenda for today's meeting. Is there any discussion regarding the agenda? Do I have a motion to approve?
So moved.
Fitzpatrick has made the motion. Do I have a second? Judge has made the second. Please state your vote for the record when called upon. My vote is aye. Dr. Bufalino?
Aye.
Ms. Goldthwait?
Aye.
Ms. Roush?
Aye.
Ms. DeCastro?
Aye.
Dr. Marciano?
Aye.
Ms. Schmitz?
Aye.
Mr. Fitzpatrick?
Aye.
Judge Mazzarelli?
Aye.
Dr. Willie?
Aye.
With that, the motion carries. Next up is the review and approval of the draft minutes from the June 9th, 2023 meeting. You've received these minutes. Are there any questions or comments? Do I have a motion to approve the minutes?
Motion made.
Bufalino has made the motion. Do I have a second?
Second.
Marciano has seconded the motion. Sorry, Ann, I know you're getting in there just a second late. It's that delay.
It's that lag.
But I will be better. Please state your vote for the record when called upon. My vote is aye. Dr. Bufalino?
Aye.
Ms. Goldthwait?
Aye.
Ms. Roush?
Aye.
Ms. DeCastro?
Aye.
Dr. Marciano,
Aye.
Ms. Schmitz,
Aye.
Mr. Fitzpatrick,
Aye.
Judge Mazzarelli,
Aye.
Dr. Willie.
Aye.
All right, with that, the motion carries. Swiftly moving through the agenda here, we're up to accreditation and laboratory updates. First up is the New York City Police Department, the latent print section. In July, A&AB conducted a renewal of their accreditation assessment. There were no findings, but one recommendation for improvement. The assessors felt that the inconclusive reports would be improved if more specific reasons were given for the individual examination were stated on the report. It should be noted that recommendations such as these require no official action. A&AB has issued a renewal of accreditation. Are there any questions for the laboratory regarding this activity? We do have one person from the lab in person and then one online.
Should we forego questions regarding the incident 8 years ago till
Yes.
later?
When disclosures later in the agenda.
Got it.
This is strictly regarding their renewal of accreditation. Okay, so do I have a motion to issue a full renewal of the New York State accreditation to the New York City Police Department latent print section concurrent with its A&AB accreditation?
Oh, sorry, could I suggest, I thought this is where you were going, DA Fitzpatrick, but should we hold off on this vote until, I understand holding off on the questions until we get to that section of the agenda that deals with the disclosure, but there's some substantial issues being disclosed that might be relevant to whether we want to reaccredit the lab or continue the accreditation. So I would suggest holding off until we hear answers from the lab about how they're dealing with the very significant disclosures.
So what I would suggest is that we continue with the motion because the information that's provided was not reflected by a finding in their accreditation. And that's what we are focusing on with this is the renewal of their accreditation, the criteria that were investigated and the standards which they were held to for that. And I know there are several questions regarding the disclosure that they do have, the time period in which it was made, and what does it actually pertain to with their direct accreditation. However, knowing that A&AB did not make note of these things during their accreditation review, I would suggest we continue to move forward with the motion. Council?
I think that's fine to do. I think if you wanted to vote, you could vote on whether to move forward or whether to hold it, or you could, hold your vote if you wanted to.
Yeah, I mean, I understand the point that there was no finding by ANAB relevant, I guess, to their determination to issue a reaccreditation, but it's certainly relevant to us. So in that vein, I think we should wait and get answers from the lab about, right, because the issues that are being disclosed have to do with whether the laboratory has a robust system for reporting, for corrective action, for looking back at past mistakes. And that is so significant, and this is such a big issue that I just think we shouldn't rubber stamp ANAB's determination that we should do our own inquiry and then wait to vote on reaccreditation after we get some much needed answers from the lab.
What I would say also, though, to play devil's advocate kind of to this, is that the disclosure that we have is an initial, it's an initial notification, and that the investigation has not been completed.
Mm-hmm.
So we don't know the extent or the details other than what the information that we've been provided with. A&AB is also looped into these communications, so that if something were to come up and it were to perhaps directly impact their accreditation in terms of being a showstopper, it would also be addressed by them at that point as well, and we would be notified at that time. I'm open to anything, but my personal opinion, which It's semi-supported by council.
Well, I think you can do either. If you want to take a vote on whether or not to proceed with this vote, you could do that.
We can do that. Let's take a vote. Do I have a motion to continue with the vote for the full accreditation of the New York City latent print section? Do I have a motion?
As opposed to considering it
To
later.
considering to pause and wait till later.
Okay.
I did what you said in your closing arguments there, and they're not closing arguments, about AA and AB has also been given the same paperwork, then I'll move the motion.
Do I have a second?
Second.
Okay, Michelle, second. When I call on you, please state your vote for the record. Dr. Buffalino?
Aye.
Ms. Goldthwait?
No.
Ms. Roush?
Aye.
Ms. DeCastro?
Aye.
Dr. Marciano?
Aye.
Ms. Schmitz?
Aye.
Mr. Fitzpatrick?
No.
Judge Mazzarelli?
No.
Dr. Willie? My vote is aye.
Aye.
With that, the motion carries to continue on with the vote.
Yeah.
That's math. I'm good. Yeah, good at math. Thank you. Okay. I'll repeat again. Do I have a motion to issue full renewal for New York State accreditation for the New York City Police Department latent print section concurrent with its A&EB accreditation? Buffalino has made the motion. Do I have a second?
Second.
Schmitz has seconded the motion. When I call on you, please state your vote for the record. My vote is aye. Dr. Buffalino?
Aye.
Ms. Goldthwait?
Abstain, we don't have enough information.
Ms. Roush?
Aye.
Ms. DeCastro?
Aye.
Dr. Marciano?
Aye.
Ms. Schmitz?
Aye.
Mr. Fitzpatrick?
Aye.
Judge Mazzarelli?
I abstain.
Dr. Willie? With that, the motion carries. Congratulations to the lab on their renewal of accreditation, and clearly we will be asking questions here shortly. Next up, we have the New York City Police Department Police Laboratory. This is for informational purposes. No vote is required. The laboratory submitted a scope change form to remove the testing of body vests due to the change in the law. A&EB has updated their scope. I'm assuming no questions. Should never make an assumption. All right. So the next lab up is Suffolk County Crime Lab. Again, for informational purposes, no vote is required. A&EB conducted an on-site assessment activity in August. There were no findings. The laboratory has provided the activity report and assessment plan. A&EB has issued the continuation of accreditation letter. Any questions, comments? All right. Next up, Westchester County Department of Labs and Research Division of Forensic Science. We have several correspondents. These are for informational purposes and no vote is required. In June, A&EB conducted a surveillance assessment activity. There was one finding related to direct observation during internal audits. The laboratory did appeal the finding, but A&EB determined the finding was upheld and would need to be remediated. The laboratory completed its corrective action and A&EB issued a continuation of accreditation. Are there any questions for this lab? Okay. Next up is the Westchester County Department of Public Safety. This is for informational purposes. No vote is required. In June, A&EB conducted a surveillance assessment activity. There were no findings. A&EB has issued a continuation of accreditation based on the results of the assessment activity. Are there any questions for the lab?
Can I ask a question following up from our last meeting about the failed proficiency testing? There was no action that was voted on by the commission. So there was no requirement that the lab report back on anything specific, but there was an extensive conversation about, someone correct me if I'm wrong, but about a failed latent print proficiency test.
Okay.
And I just wondered if there had been any more investigation by the lab.
Is
Division, it's Jim.
Jim Harrison in Albany, I think, and he sets the table.
Hey, how's it going?
Good morning.
Morning.
Good morning. Good morning. At the last meeting, you had disclosed a failed proficiency test and an investigation into it. The commission didn't take any particular action with respect to your investigation, but we did have a fairly extensive conversation about it. I just wondered, had there been any follow-up that you would share with the commission about your investigation into the issue, or do you consider it closed?
I consider it closed. It was raised during our document review with ANAB, and there was no further action on their part. They accepted my corrective action.
So no investigative steps were taken after the last commission meeting, do I have that right?
Correct.
Thank you.
Anyone else?
You're welcome.
All right. Thank you. We'll move on to the Yonkers City Police Department Forensic Science Laboratory. This is also for informational purposes and no vote is required. In May, ANAB conducted a surveillance assessment activity. There were no findings. The assessment report and activity plan were presented and reviewed in the June meeting materials. The laboratory has now received their continuation of accreditation documentation from ANAB, and that has been provided to you for this meeting. Are there any questions? All right. Next up is old business. Familial search update. You've heard me talk enough, so I'm just going to turn it over to Ms. Glavin. You want to provide an update?
Sure. Good morning, everyone. Last Thursday, I actually took a walk down to the Court of Appeals and sat through the oral arguments on the familial search matter. The court was very engaged and had a lot of questions. So it was very, I had a nice afternoon down at the court.
Did you explain to the court the difference between the DNA subcommittee and the forensic science committee?
I decided that it was a good idea for me to stay quiet with that. So I spoke with the AAG who argued the case. He anticipates a decision, he said 4 to 8 weeks.
Who was the assistant who argued it?
Matthew Greco, who has had the case the whole time. So he argued it at the appellate division and wrote the briefs. And we had a meeting. We had a prep session with several members of the AG's office, including Solicitor General Underwood, and thought that was helpful.
Anyone, it's all recorded. Anyone can watch it if they want to.
Although I have been unable to locate it on the Court of Appeals website, which does not appear to be updated. But
It takes
hopefully,
about a week or two.
yeah. That's what it says. It says the Monday after, but I was unable to find
Yeah,
it.
I haven't seen it either.
They have a YouTube channel, so they
Right.
have a lot of stuff up on there. But I couldn't find any of the newer cases, but maybe they're just a little bit behind. But it should be up, yes.
And I want to say that not only the recording of the argument, but the transcript as well would be updated whenever they update the website.
Right.
They say it was to be updated last Monday, but
Yeah,
it's
so.
not there.
But we'll keep checking.
I do think some folks from the lab some of the labs were able to find it on YouTube though.
Okay.
So it does exist out there because some folks did watch it after the fact.
The link that you usually click on is not
Not there.
active yet, but there's a ton, when I looked, they were having a hearing. So I mean, they're definitely live streaming things.
All right. Any questions regarding that? Or they're just in a holding pattern, wait and see 4 to 8 weeks?
Prior to familial searching,
Yes,
I think we referred to it as inadvertent matches,
still happens, partial match.
partial matches. So that process is still in effect.
Yes,
Okay,
separate and aside, not part of this law,
got it.
law of this case. All right. We'll move on to the Niagara County Sheriff's Office Forensic Laboratory. This is for informational purposes and no vote is required. A&AB has issued their report regarding the anonymous complaint. A&AB determined that of the 7 allegations, only 1 was founded and the laboratory was in the process of remediating that. Last week, training was conducted at the Niagara County Sheriff's Office in accordance with the recommendations that were set forth by the commission and agreed to with the laboratory. Additionally, the working group met with Director Giffen to hear about the progress regarding the other recommendations. Lydia, not to put you on the spot, would you like to provide a brief update? And if you need any assistance, we are here as a working group to also chime in.
From the last meeting?
From the working group.
Just in general with the working
From
group?
what we had updated with Christine when we met with her last week as a working group.
It sounded as though they are getting some support based on the recommendations that we made. In particular, I believe that they had, was it root cause training? What was it that they had for the week?
So it was ethics, ISO criteria, and root cause.
Right.
We're all a part of that, yeah.
So one thing that I thought was really important based on our early reviews was that their reporting structure, who are sworn, we wanted them to sit in on these trainings so that they could understand more about what it is the laboratory is facing. And based on Christine's feedback, they were actually interested and learned something. And whenever you have people who don't understand what we do, any opportunity that we can have for them to learn something is a good thing. So that was good to hear. And apparently the staff is also very engaged in what it is that they're doing and what they're learning. So they feel positive about what's been happening so far. I think there was something else.
QA manager?
Yes, they hired a QA manager. He's coming from Texas. So we did think that it was a positive thing where that's also coming from a state that has an oversight commission body. So he's familiar with, this extra scrutiny, if you will, or scrutiny and support, I'll put it that way. And, but he hasn't actually moved yet. There's, moving from Texas to Niagara County, New York, we were like, why are you leaving Texas for the snowy north? But apparently he's all in with that, but he hasn't actually physically moved yet, to my understanding. And, I think that the feedback that we gave, we all felt like, there was positive progress, but there's still some more that has to be done. And I can use some help now with whatever else we had said. Did I miss anything?
I think that was it. Anyone?
Yeah, no. Okay. Guess I don't need any help.
Did a great job. Thank you so much.
Why, thank you.
Can we ask questions about this report?
Brad is available.
So we have Brad Putnam, excuse me, from A&EB available on the phone as a representative, and also Christine Giffen, the lab director, is available on the phone as well. So I'm not sure who your questions relate to, but why don't we just be proactive and elevate both of them?
Jill, while we're waiting, I think you said in your recap that
Yes.
ANAB had one
There
finding,
were
there's
two.
two.
There
Okay.
were two. Thank you. Jessica was on it.
There were
Good
two.
morning, Brad and Christine.
There might be four by the time I get done, but anyway. Well, this is.
Who are your questions directed to, so we can
Well,
just make sure they're
my
unmuted?
first question has to do with allegation number one, and it is really not so much directed to the authors of the investigation as it is to my fellow commissioners. And if you look at allegation number one and ANAB's finding, and I'm reading here from page 106, there are conflicting statements from the parties involved as to whether the authorization form was signed before or after the laboratory director received the evidence. Either scenario is acceptable to ANAB. Either scenario may be acceptable to ANAB, but it's not acceptable to me. I'm curious if anybody else feels that way.
Didn't,
Go ahead.
didn't we just have testimony on that issue in April?
So I think what, and again, anyone else feel free to step in. The bottom line was that the training was conducted. It's whether or not when the form was signed was issue, but ANAB found that the training being conducted checks the box. The form being signed at 8 a.m. versus 2 p.m.
Or Monday instead of Friday. I don't believe in little white lies when it comes to what we're doing. If nobody else cares, I'll go on to my next question.
We went into this extensively.
But Judge, what have we done forensically to determine? I don't know if these are handwritten or electronically generated, or
I think that
who said what.
I was under the impression that the agreement that we entered into with them would help them to overcome and to stop doing anything like this, to understand the seriousness of what was involved, and that it wasn't, what we were doing wasn't to punish them or to sort of call them out, but it was to help them do a better job.
Assistance in better record keeping
Right,
and understanding
right, and
that, yes.
for them to understand the gravity of what had occurred, that there are no little white lies.
No,
Yeah.
no one wants Niagara Lab to succeed more than me. I've talked to my colleague there extensively about this, and the taxpayers of Niagara County deserve a bang for their buck and good evidence production. I don't have any problem with that.
No, I think my point is we've been over this.
But, well, when you say we've been over it, we just keep like moving it down the road. No one has, from a law enforcement perspective, convinced me that this person misled the commission, this person was truthful with the commission, as opposed to just saying, well, we can't resolve it, so it doesn't matter anyway.
Well, we
It
didn't
matters to
say
me.
that. We didn't say that it doesn't matter anyway.
ANAB is saying that. That's my point. Either scenario, whoever lied, it still doesn't matter. That's what they're saying in nicer language than me. All right, nobody else cares.
No, I agree with you. It does matter. It does matter. Falsifying a business record matters. Yeah, I agree.
My thought was when I read there are conflicting statements from the parties that, okay, so is that the basis? Well, because it's conflicting statements, we can't resolve this, so let's just move forward. I mean, I'm interpreting that. So since we have somebody available to talk to us, maybe they can tell us how they came to deciding that this was without merit. Because that is what jumped out to me. It's like, well, we heard this, we heard that, and so is that in their mind a wash? And because that's a wash, they're done, and everything else that was done seems to be okay. So I'm kind of interpreting what they wrote here, but maybe they can give us a little more insight into that, because I was surprised by the finding, I would have to say.
After the hearing, ordinarily, the kind of hearing that we had would result in sort of a report with findings of fact and finding of facts and law and recommendations, but we didn't do that.
We did not.
Right?
Because we entered into an agreement with the
Right.
lab
Right.
in lieu of that.
Right, so we didn't come to any conclusion about this, although I think the testimony was very strongly in one direction, that there had been inaccuracy, to put it nicely, in the sign-off. But
we also were waiting for this. If I remember correctly, we said that, all right, well, ANAB was there during that special hearing, and we were waiting for this, and now we've got this report, and now we've got more to talk about.
So maybe the ANAB representative, I'm sorry, I forgot his name, if he could just say that they're unable to, I'm just curious as to what efforts they made to determine the truth or falsity of the
Mr.
statement.
Putnam, can you speak on that? Although I will say I do know that Pam Sale was the one to do the on-site visit for this, and she is doing her civic duty, at jury duty at this very moment.
Good luck, good luck.
So Brad has
Keep her,
been,
Jessica.
Brad has been thrown to the wolves here.
and I was supposed to go the other day too.
Yeah, good morning. So I can't speak to the actual investigation.
God, who's that?
Because it's pointed out I didn't do it. But I can report on the finding, and we investigate all issues in accordance to accreditation requirements, both 17025 and AR 3125. Understand, so the merit would be gauged against those requirements and not particular laws or commission standards or expectations, if that sheds any light on what without merit may mean.
Go ahead, Pat.
I've got a question for us. I thought one of the allegations had to do with a form that was being investigated, but I don't see that as being one of the allegations that were reviewed, unless I'm missing it. It dealt with training.
I thought it might be allegation two, you don't think so?
Yeah.
Where the date on the bottom of the form was, the date the form
yes.
was corrected.
Yeah, I think you're right.
That's two.
That's number
Right.
two, yeah.
Something on memo that was printed, that's it, prior to its issuing, like if it's a brand new memo that was just created, but a date that was signed that was number two?
That's the way I'm reading number two, but maybe we can get clarification. One of the issues with this is there's not a lot of detail in the
Right.
summary report.
I guess that's my question for Brad then. Brad, does this make sense? Was that covered in allegation two, if you're familiar with the investigation?
Yeah, I'm just looking at Ms. Sell's entries into our log, and it does appear to be regarding the work authorization and memo dated September 9th, 22. Is that the form regarding an unsigned memo?
I think that's.
Well, I think the memo was signed, but it was signed before, the date it was signed was before the actual creation of the document, implying obviously that it was backdated. So we may be talking about two different things. Yeah.
I think so.
I saw the form.
Yeah.
Yeah. I'm trying to pull it up.
Could we be provided the results or the investigation itself? So there might be something there that we can use in order to make a decision? I don't know if that's possible, but it's a.
I don't know I don't know.
Yeah, there's nothing to vote on today. Right?
No, there's nothing
So-
to vote on today, but I don't know what A&AB.
We could make a request for additional documentation from ANAB.
Just the method of investigation, things like
Under New
that.
York discovery rules. Right, Jessica?
Mhm.
Yeah, we'd like to see.
I like discovery.
Will you stop? Will you stop?
Do we need to take a vote on that request for additional documentation, or can we just say,
I think
A&AB, could you please provide us with documentation that was used for the conclusion of your findings memo?
Yeah.
So
Take a vote.
I'm sorry to understand the request. Is the request for the actual documents, or would the request be for a list?
For your investigative notes, perhaps?
Yeah, I think that I'd appreciate if that was made as an official request, and then of course that would have to go through our legal, to review the request and our right liability to provide the documents.
So then I'm going to make a motion for vote that the Office of Forensic Services write a memo or letter requesting investigative documentation relating to this conclusionary report for Niagara County Sheriff's Office. I've made a motion.
Second.
I think that's good language.
It's good.
Maybe not good English, but it's good language.
Covers generally.
Lydia is seconding that motion. I will take a vote to see if the motion carries. Cheat sheet of people up. All right. When I call on you, please state your vote for the record. Dr. Buffalino?
Aye.
Ms. Goldthwait?
Yes.
Ms. Roush?
Aye.
Ms. DeCastro?
Aye.
Dr. Marciano?
Aye.
Ms. Schmitz?
Aye.
Mr. Fitzpatrick?
Aye.
Judge Mazzarelli?
Aye.
Dr. Willie?
Aye.
Okay, so with that, the motion carries.
Your vote, Jill? Did you
Oh,
say
my
aye?
vote, wait, my vote is aye. Sorry, I made the motion, I just assume, and I know that's not correct, so my vote is aye. With that, the motion carries, and we will draft that official request to A&AB.
Hold on, Jill.
No,
What?
there's a hand.
Dr. Willie?
just a comment about how the way the working group has proceeded with working with Niagara Lab, with the expectation that we really weren't dwelling on what had happened. We were simply hoping that by training and input and collaboration, that we would move forward with a lab that was in much better shape in terms of dealing with their activities. So just so you know, we made no effort to resolve dates and signatures, and we said that's water over the dam. We're moving forward. This is a collaborative, productive, positive training activity. I can understand the different perspectives about wanting to resolve it from an evidentiary legal perspective. There's been no effort or intent from the working group to do any of that. Is the lab in better shape now than it was? Absolutely. Does it have a way to go, as Lydia said? Absolutely. Are some of their future plans in need of review and input? Absolutely. And we intend to continue to work with them. But dates, times of signed documents of the past have not been ours in any way.
And just to add to that, I think what we came to a conclusion was that all the testimony presented in front of this committee was not under oath. So we just wanted to move forward to correct any possibilities and move forward and not worry about whether it was substantiated or not.
You didn't swear the witness.
Okay, so did you have additional questions regarding?
No. The only comment I have is that, some of the allegations, when the conclusion is the allegation is without merit, I don't know if that's a form that has to be used or something, but for example, the allegation regarding the lead residue, it certainly has some merit, as does allegation number 5. So I don't know if there's alternative language that can be used, like the allegation has some merit or the allegation has been investigated and been resolved. But anyway, let's go on.
Anyone else?
Well, that would be a good thing if we just had a different kind of language here. That would be, even for this one, to say it's without merit. It's clear that somebody signed it, and they could say without, the allegation is without significance, something like that. And then we wouldn't have to have this sort of contradiction, I think, is the best way to put it.
I think too, if there are individual suggestions on to what we're looking for, we should send them to OFS. Specific language for the crafting of the letter.
Or we can wait until we see what materials are provided by A&AB to then see how they may have reached the wording that they've selected.
No, that's what what I mean is.
I could speak to the wording
not about their wording.
Our complaint procedure has specified outcomes for each allegation. The complaint procedure is company-wide, so while we will certainly consider recommendations to changing language, it's significantly bigger than the forensic business unit.
No, that's not what I meant. I meant that if members of the commission would like to see certain, to be clear about what exactly they would like A&AB to provide, not how to write their reports, what the supporting documentation is.
Okay.
Related to.
For example, on allegation number 7, the language they use is maybe it's equivocal enough to be satisfactory, just to say it's closed. That doesn't say that it's without merit or with merit. It's just closed.
Right. If there's no investigative notes or those specific things that would be helpful to the commission to evaluate their final determinations. Does that make more sense?
It does. Thank you.
Sorry.
Anyone else?
I have to ask if what we were told is that there was merit or no merit based on a comparison or a review of the standards. What standards, right? I mean, it would be better to see the allegations without merit based on standard whatever. Because I agree, it's very vague.
Do you have a particular allegation that you would like information regarding the investigation to what specific standard?
All of them.
Okay.
And maybe a definition if it is defined by ANAB of what without merit means. I know you explained it, but if there's something written in the standard itself or in ANAB documentation, that would be helpful.
I don't understand where we're going with all of this.
Judge, what do you think?
What do I think? I said, I don't understand where we're going with all of this.
So
Well,
the-
where we're
Because
going, where I'm going is, I don't think this report is complete and adequate. That's where I'm going. For example, allegation number 4, safety concerns related to lead residue, blah, 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 were with little or no response. That allegation is without merit. The previous paragraph says it's still going on. So there's some merit to it. When was it brought to the attention of the administrators, and when did they direct it? I'd like to see that in the report. And then I move on and go back into obscurity.
You're talking about number 4?
Yeah, just as an example.
Well, the finding is that they're taking immediate appropriate action to find a solution to the ventilation concern. Well,
I can hire an HVAC guy, I'll get the thing solved tomorrow. I mean, what the hell is the problem?
But we spent a whole day taking testimony from a number of witnesses. We made a choice, as I said before, not to have a report, the findings of facts and conclusions of law, and to make a recommendation. We made a decision to put together a study committee to help work with the lab. They came up with a settlement. Am I correct or not? You worked very hard. Everybody was in agreement. There were no objections to the settlement that they came up with, and they're working on that. So I don't understand. I think we're just going over stuff that we already went over in great depth. So explain to me what I'm missing, please.
Well, I agree with you that there was some unanimity, but I will also stand unequivocally and say that at the last meeting, I said, I want this credibility issue resolved. I'm certain I said that.
You did.
You did.
I think there are two things going on, and they shouldn't be incompatible. One is a desire to move forward with the Niagara County lab, improve its practices, and the lab has made strides doing that, hiring a quality manager, participating in the working group meetings. So I agree with that, Judge. But I agree with DA Fitzpatrick that it's essential for accountability, transparency to the public, that there is a thorough and complete documentation of what happened to lead us to this spot.
So then we
certainly
should
the people
have
of
done-
Niagara and really all of New York need to know this. And this report is so vague. And really, it borders on misleading. I think everyone who heard the testimony or read it, which is all of us, was surprised to see no merit for many of these. So it's not that we don't want to move forward. I'm sorry.
We should have had, maybe, and then we have to go back and do a report with findings of fact and conclusions of law. That's what.
We agreed not to do.
Yeah, but that's essential. This report in the abstract, without the benefit of that full day's hearing, testimony, would be incomplete. I mean.
Well, this is incomplete, right?
I think that a review of the standards is maybe appropriate, just to put some context in, and maybe some of these words are used. I think that they mentioned, like, these might be the terms of art they use when they complete all of these reports. And if we had some definitions or some more clarity on how that comes about, that might be helpful for the commission.
I mean, I know I personally came to certain conclusions in my own mind as to the credibility of certain witnesses, and I would venture to say that many of the other people here reached the same conclusions, but the commission made a determination that that wasn't what we were going to be doing. What we were going to be doing was trying to work with the lab forward and correct the conditions.
I think it's agreed upon, right? But wouldn't this enhance our understanding, right, of the situation? We had the hearing, and now ANAB releasing a report based on their investigation. I think it would just enhance the understanding for us.
The understanding of what? We heard one version, and then we heard a completely opposite version of the same set of facts. That's not an unusual thing in a hearing or a trial. You know, you get the prosecution, you get the defense. And somebody's got to decide where the truth lies. Now, we made it, we made a decision not to do that. We made a decision not to call out people as liars.
Well, we made a decision that based on our role as a commission, let's put this out here again. I think I said it last meeting before, 9 million meetings, I don't know. Our role as a commission, and what do we do? And we take a look at the quality of the analytical work that is leaving the laboratory. Was that impacted? Was there issue where it needed to have it be so the laboratory would be shut down? And we came into an agreement with the laboratory that there were improvements that needed to be made. We made these recommendations and we moved forward, right? We provide the training opportunities. We took a look at, so the allegation, whatever it was, you know, the training document being signed at whatever date, whatever time, the training was done. That's the conclusion that was reached on that. To me, that's what's important. That's what A&AB finds important, because the training is what needed to be done by that specific person in order to reach the status to move forward.
Well, the message also has to go to them that you can't finagle, you know, with
100%, 100%. You know,
I think we delivered that message.
I just want to put this to bed with this last statement, all right? I have 50 assistant DAs that serve at my pleasure. No one in 30 years as the elected DA who is employed by me has ever lied to me twice.
Twice?
And that is important to me. My fellow commissioners may not share the level of importance that I find, and I understand it, I respect that, but it's not acceptable to me that somebody comes in front of us and misleads us, say it in a nice way, misleads us, and then say, well, okay, that, you know, go forward, my child, and sin no more.
Yeah, but we didn't have any power to fire these people.
well, we didn't have any evidence.
We have the ability to believe them or not believe them in the future. That's my point. So with that, let's move on.
We're going to move on. Okay, we're moving on.
That was a motion.
That's you're making.
Jesus Christ, I can't take these. Can't we just go, everybody in favor say aye all at once?
Well, we got locations, we got phones, we got people, we got lots of things going on. So I'd like to be official. I don't want my lawyers to get mad at me. The lights are.
I never get mad at you.
Are you sure you're doing that? Move on.
Lawyers never get mad at making motions.
You just have the lights flicker. Greater
Makes
being
money
here.
for them.
We don't get paid by that.
So again,
We had this liar on the stand 100 years ago, and he's this defendant. Forgive me, Jessica. And there was this bolt of light. And there was a great moment. The judge like, "Are you sure you're telling the truth?"
yeah, so on that note, I'd like to live another day. So again, thank you, working group. I just want to say, you know, it is additional time that we do need to do this, but I think it's very important to know that we're here as a resource. This is not meant to be an adversarial relationship.
What are you looking at me for?
I'm just saying, you know, we just need to move forward here. All right, lab disclosures up next. Thank you so much, everyone. Erie County Medical Examiner's Office of Forensic Toxicology Laboratory. This is for informational purposes and no vote is required. This is an initial notification and acknowledgement by A&AB of a reporting nonconformance. It was determined that the address of the requesting agency on the reports was outdated. This was found to have affected 5 cases, and the laboratory determined this was an isolated incident. Following a monitoring period of 2 additional cases were observed and amended reports were issued on those as well. The laboratory has deemed no further action is needed, and a closeout to the corrective action was issued. Were there any questions regarding this? All right, Monroe County Forensic Toxicology Laboratory. This is for informational purposes. No vote is required. This is an initial notification, acknowledgement by ABFT and closure of a reporting nonconformance. This was, it was determined that the results for cocaine were repeated on a report. For, what is it, for cocaethylene, instead of reporting non-detected or none-detected. During the root cause analysis, an additional report was determined to have a typing error. The lab has conducted its root cause analysis and considers the matter closed. ABFT, again, this laboratory in particular is still ABFT transitioning to ANAB, has reviewed the notification and finds the laboratory has taken appropriate actions. Are there any questions?
Yes.
Can we get Rebecca Hartman on the screen? All right, I see Rebecca. Oh, she's unmuted. I may have butchered that. I apologize. Please feel free to correct anything I may have misrepresented prior to questions.
I think it was a fair summary.
All right, thank you. Jessica?
Good morning.
Good morning.
I had a question about, and forgive me if I botched the pronunciation, but cocaethylene. Is that formed in the body when cocaine and ethanol or alcohol are both present in the blood at the same time?
Yes.
Okay, so like if you use cocaine and drank at the same time, your body would come up with cocaethylene?
That's correct. That's when we would see it.
Okay. And that was a substance that was mistakenly listed as present with some value, even though it was not in fact detected?
Right.
Okay, okay. I had a question about how results go from, I guess, the instrumentation or the interpretation by the analyst onto the actual report. Are they hand transcribed? It sounded like they were, but I may be misunderstanding. The software doesn't sort of automatically import the values?
No, we don't have that capability. They are hand transcribed. So because of the way our county's IS works, we very deliberately cannot have the instruments hooked up to any kind of network because it messes them up. So they are completely offline and isolated from everything else. And results are processed, but the final results get typed onto a report by a transcriptionist.
Is there, I just don't know, is there the existence of some kind of software that would bridge that gap so it wasn't manual typing, or is standard practice in tox labs to do manual input in order to protect the instrumentation? I don't know.
Not really. It depends on, again, how the various jurisdictions are set up. We don't have that capability. We are in the process of trying to build a system that's going to eliminate the potential for more of those typing errors, but it's been problematic to try to get it to meet our needs. So we can't deploy a new system until we're confident that it's going to serve our purposes. So in the meantime, we have the system that we have, but the person who made that mistake, it happened twice, looks like within about a week, and never again from what we can tell. And, she was fairly new. And so we think by the time it was discovered, it had already corrected itself, but we're still keeping an eye out to make sure that that's the case.
Were you, and I may be mistaken, but was part of your corrective action to sample a certain percentage of cases just to monitor and make sure that there were no repeat of errors?
Yes. So we looked, when we were doing the investigation, we looked at a year's worth of our cases. And in terms of the monitoring moving forward, it was approximately every 5 cases that came out of the lab under the system for a period of 2 months.
As you, I think, properly noted, you were particularly concerned that, okay, mistakes happen, right? But it wasn't caught during the review process. And I think you rightly emphasized that in your report. I just have a question about the, I know one was a typographical error, but with, I guess, big import. Instead of 0.886 micrograms per milliliter, if I'm saying that right. The actual value reflected was 8.86 micrograms per milliliter, and this is for a substance I can't pronounce,
benzoylecgonine.
Benzoylecgonine. Thank you. I'm just curious, I don't know, is 8.86 a fantastical value, or is it in and of itself in the realm of possibility? I just wondered how much of a flashing red light that would be on a report, like, or do you occasionally see 8.86s, or is it something that would be really wild? Or impossible, even?
Yeah, I wouldn't say it's impossible. We get some pretty substantial overdose cases, but it's not common that we see it that high. No. It was, yeah, again, a decimal point that wasn't, in the review. They didn't notice it was in the wrong spot. But.
Yeah. And my final question, I think, for you is the 2 cases that did have the errors, you indicated that you had caught the error before they had been prosecuted. And you explained that neither had gone to the grand jury at that time. But I'm just curious, what is your definition of prosecuted? Because sometimes we use, right, there's a difference in how legal, lawyers and courts use a word and then how normal people use the word, right? So what is your understanding of when prosecution starts? It's not, I just am genuinely curious when you think prosecution starts.
Well,
this isn't a gotcha question. I
mean, from our perspective, our report had not been used in any legal proceedings because those were, beginning with, the grand jury in terms of our information directly being applied for the purposes of this particular case. And it was in the lead up to that this was discovered. So of course, we notified immediately, so there was no action that could have been taken with the incorrect information because we let people know as soon as it happened.
Yeah, good. The reason I ask, again, it's not a gotcha thing, it's just, and I understand, right, a formal definition, I suppose, of when prosecution begins is when there's a filing of an accusatory instrument, like some documentation that begins the process. I don't know anything, obviously, about these 2 cases, but when somebody is arraigned on a criminal court complaint or a felony complaint before grand jury action happens, I'm not saying this is remotely true in these situations, I do not know, but sometimes forensic evidence is a part of, say, a bail application or whatnot. So sometimes these things matter at an earlier stage. I know as soon as you detected the error, you reported immediately. Unfortunately, it was caught before a grand jury's presentation, which is critical. But I think it's sort of an interesting issue where, the law, or I've said this in past meetings, is sometimes the defense perspective or the larger legal perspective of when things matter, when forensics matters, is not always I think, the same as what labs think, right? And we probably need to do a better job on both sides, sort of communicating that. So that was a rambling way of saying it might have mattered even at an earlier stage. I know you disclosed it as soon as you caught it, but even before a grand jury, these things can matter. That was the only point I wanted to make. Does that make sense?
I guess. I mean, I don't think it could have changed anything in terms of what we could have done. You know, from our perspective, unfortunately, it doesn't really change anything. But I hear what you're saying, and I do respect that and understand that. But, you know, I will say that we went out of our way to inquire to make sure that nobody had had any negative outcome from this, you know, because of this mistake. You know, the other case, grand jury had been, you know, everything had been postponed on that particular case and pushed out and pushed out. And, you know, I actually asked the question, you know, did somebody take, you know, was this canceled because they, you know, saw the case? You know, was this postponed because of this? And no, it was completely unrelated. So I guess, you know, we got lucky in that sense. Things got slowed down a little bit in the process, you know, but I did make a point of making sure that this didn't, you know, mess up somebody's life or whatever it is.
Yep, thank you.
Any other questions?
No. Yeah, just one or a couple. Hi, Rebecca, how are you?
Fine, thanks. How are you?
The reports, are the draft reports handwritten?
Not handwritten, they're typed.
So even the drafts are typed?
Yes.
As a draft report, okay. So the typist, is the typist also a scientist analyst, or are they just so are they familiar with the jargon, or are they just transcribing what's coming out of the results?
So the answer to your first question, no, she's not a scientist.
Okay.
We hired her in part because she had some familiarity with drugs from a former position that she had held in clerical work, you know, but she is our evidence clerk. So she, you know, will receive the evidence, but she does not perform any analysis on it. And, you know, she's learned a lot about drugs from us, of course, but she's not herself a scientist.
Sure, but especially with the metabolites, they're in like benzoylecgonine and all that kind of stuff. They can all just get jumbled up in your head. But I wasn't sure whether it was just like I have no idea what I'm looking at, as opposed to, oh, maybe as you said, people are human, and you're on autopilot, and you think you're typing this, but you actually saw something totally different. So. I also wanted to jump in on, so is your IT department called, it's IS? What is your, whatever it is?
I don't know. I kind of use them interchangeably. I think IS is information services versus, you know, it's the computer overlords, you know, that we operate under here.
I think that's a better name, especially we have the same issue in our laboratory about certain instruments. There's a problem where something gets kicked off, and, you know, the computer's working, the instrument's working, and then the data doesn't get transferred because something happens with IT, and, oh, you don't have Windows 42, and, you know, if you don't have that updated version, then we don't want you on the network, blah, blah, blah. So just wanted to bring that out there, that this is a common problem for us, and that trying to set up an interface between the instrumentation and whatever software that we're using to compile information and write reports is an ongoing problem. So I understand. That's all I got. Thank you.
All right, thanks, Rebecca.
Thank you.
Yeah.
Yes, setting up a safe interface.
Yes.
Okay, so next up, we have the New York City Office of Chief Medical Examiner, Department of Forensic Biology. This is for informational purposes. No vote is required. This is a notification regarding an unidentified human remains rank in CODIS. Based on inaccurate information inputted into CODIS in 2017, the OCME determined that there was a no match that should have been a match. The error was observed in 2023 when the sample rank led to a determination of John Doe, and the 2017 no match had to be reviewed. The OCME is conducting a retrospective quality review, and the DNA subcommittee had reviewed the notification also in August. Are there any questions for the laboratory?
Yes. I have one question.
Question? Okay. If we could have Kira.
It's real quick.
Hi, I'm Kira McKay. I'm the quality assurance manager of the lab, and this is
Ms. Nara.
Ahmed.
I'm a controller at the same laboratory.
In the missing persons unit.
So you reported 2 actions that the lab is taking. And so action number 2, it says the CODIS rank evaluation protocol has been improved. Whose protocol? CODIS's or OCME's protocol?
OCME's.
Okay.
OCME's protocol for evaluation of CODIS ranks for unidentified human remains and any kind of ranks. And a second review was instituted in our review process.
Go ahead.
Jessica?
Or you want to go first? Which out-of-state laboratory gave you incorrect information?
I would rather not say. I'm trying to keep the name of the laboratory out of this.
Why?
I just felt that it was not appropriate for me to share that, and because it has to do with, sensitive information for missing persons cases. I just wanted for the commission to know that this was an out-of-state lab, so you were not fearful of something being within New York State sharing incorrect information.
Does this out-of-state lab do a lot of work with New York State labs?
Well, for missing persons, yes, a lot with New York City. I can't speak for the other laboratories, but that's why part of the review process, the 2 steps that we're taking, is to evaluate all no match ranks with this laboratory outside of New York State to confirm all these no matches since the dawn of time, basically, with CODIS.
As part of your corrective action, you said you were going back to every no match CODIS rank for unidentified human remains to relatives, missing persons. It's not complete as of yet, your review?
No, it's not.
Okay. I understand it's ongoing, but have you, as this time, found any additional errors?
No.
How many have you reviewed? How many cases?
Probably, it's pretty time consuming to go through each case and find metadata. There are different places to find that information, so it's an ongoing process. We hope to finish that by the end of the year.
Yeah, that's our goal by the end of the year to finish all this. It's still kind of in the beginning stages to go through. Milo had set up the process to go through what information we have on hand with the case files and within CODIS to see if just by the DNA data we can already confirm that it was a no match. And then the second stage is those ranks that we could not determine again to be a no match by the present data. We have to reach out to the laboratory. So that would be a formal request with the lab. The out-of-state lab does know that we're doing this, so.
Does know.
They do, they know, yes.
Really, I have a question. Hi, is the laboratory, the out-of-state laboratory, is it a private or public laboratory? Is it?
Public?
I believe it's a public laboratory.
Is it east of the Mississippi?
I try to kick him, he just does not get it, guys.
When it comes to
Oh my
person.
God, I can't.
Pat, did you have one?
Yeah, just a quick question. So I'm, and you know how difficult it is for me to understand things. Did they,
Yes, we do.
did they dispo this as a no match and you guys just went with it?
It was, when it comes to discussions of ranks, a lot of the decision-making, as I understand from learning from Milu, for this is determined not just by the data in CODIS, like the actual mitochondrial DNA, nuclear DNA, it's from discussions with the other lab about the metadata, meaning like, you know, how tall was your person? What relatives do you have? Like, when did they go missing? What approximate age? What bones do you have? Things like that. So it's through discussions. So some of the information that was believed by the laboratory, the other laboratory, when we looked into this in 2023, we realized that they were under like wrong assumptions. They thought that an ID had been made based on for this same person. So they're like, well, this can't be a match. So that was what was relayed to us and was agreed upon.
Kinship-wise, was it a compromised profile so the statistical value dropped, or was the stat there but the metadata just didn't make sense?
I don't know.
I mean, the rank pulls up through statistics, so it has to meet a certain threshold before it comes up as a possible association, and then it needs to be investigated. And during that investigation, or during the review of that rank in 2017, it was just the wrong information that was conveyed to us.
And
that
missing person for the family reference samples was already found.
Okay. But it wasn't just a low, and again, I know they don't use likelihood ratios, they convert it to the kinship ratios and so forth, but that wasn't the issue. It seems like it was just an issue of the background.
Yes.
I understand. Thank you.
Any other questions? All right. Thank you. Thanks. We'll move on to the New York City Office of Chief Medical Examiner, Department of Forensic Toxicology. This is for informational purposes. No vote is required. This is a notification regarding a PT issue where the lab identified parafluorofentanyl isomer, but the intended result was to be orthofluorofentanyl. ANAB has been notified and acknowledged receipt, and the laboratory considers this event closed. Do we have any questions for the lab? Pat, can we get Gail? Gail should be on the phone. Can we get her up on the screen, please?
Hi there.
Good morning, Gail. Okay, Pat has a question.
Hey, Gail.
Hi, Gail.
How are you? So it's just one question. So for the situation with the isomers, the orthometal and para, para is controlled and the other two are not? That's how it goes? Is it? That's a question, I should say.
Yeah, no, the ortho and the para are now in control. The ortho was added to the list in June.
Okay, so were all of these situations were just related to deaths that had no other investigation that was criminal? Like, can you, not knowing that you can't separate these on the column, could you charge for it?
So we've now done some additional work and we can separate them, but out of an abundance of caution, it made more sense for us to refer only to fluorofentanyl, and that covers the ortho, para, and meta. And so during the proficiency testing results, we went back to the test, had a look at where the ortho fluorofentanyl retained, the retention time was different. So we could see there was a shift, but it was not significant enough for me to feel comfortable in reporting definitively that we were seeing ortho versus para. So we took the decision, which to me is maybe being a little bit more conservative than we should, to report only fluorofentanyl. And I appreciate that that might cause some problems for prosecutions going forward because we're not specifying whether it's para, ortho, or meta. But that is the decision we're making now because that is scientifically the best course that we can take, not knowing if we're definitively separating them or not.
It's conservative. It's a good method. Thank you.
I have a question. If I understand correctly, ortho was added to Schedule 1 much later than parafluorofentanyl. Is that right?
Yes, that's right.
So
yes, that's right.
Is there the possibility if there's, and please jump in anytime if I'm misstating something, but if there was a question about the lab's ability to separate or distinguish between para and ortho, I guess, is there any possibility that you reported something out as para, which was illegal, continues to be illegal, and ortho before ortho became illegal? Does that make sense?
It does make sense. And no, that's one of the things that we checked with the local, with the NYPD lab and also our drug enforcement agency and also the border control who are dealing with the drugs that are coming into the state. And I asked if they had seen ortho during this time, and they haven't. And nationally, everyone has been reporting parafluorofentanyl as the only isomer that has been seen. So we were very confident, as well as reviewing the cases to show that there was not that shift that we'd seen with the proficiency testing sample. So we're confident that we're absolutely are continuing to identify parafluorofentanyl, but we're now just referring to it as fluorofentanyl to be cautious.
Okay, thank you.
Sorry, I just understand.
No, I'm not sure I understand. But that's okay.
Any other questions? Albany? All right, thank you, Gail.
Thank you.
All right, next up we have the New York City Police Department latent print section. This is for informational purposes. No vote is required. There are 3 matters. I know we have questions regarding one of them, for sure. I would like to take them individually if possible, so as to not confuse the masses, i.e. me. So we'll talk about the first nonconformance, which is an initial notification in regards to an internal proficiency test, where an analyst did not conclude an identification to an individual that was present in the database search. This examiner has been removed from casework and their negative cases are being reviewed. The investigation is ongoing and they will report back to the commission. Do we have any questions for this initial notification?
I guess have any errors been detected thus far? I understand it's ongoing.
Lieutenant Joseph, do we have you? Can we step to the table, please? And I know we also have Jennifer Lady is on the phone if you want to elevate her in case she needs to speak to any of this.
Thank you. Hey, good morning, everyone.
Good morning.
Morning.
So I understand as part of your corrective action and investigation, you're looking back at the cases of the analysts who failed the proficiency test. Have you found any additional errors?
Right now, thus far, no. And the investigation's still going, so nothing is complete yet.
Do you have a sense of how many cases you'll be reviewing in total?
There should be a total that he has of 44 cases.
And how many have you reviewed so far?
So far, we've got through half.
Okay, thank you.
Any other questions regarding this particular matter? Okay, I'm gonna go a little out of order. We'll do it the next one. The third nonconformance is an initial notification and closure involving a missing case file. The laboratory received a request for reanalysis of a 2010 case, and the folder was not able to be located. The laboratory has been unable to determine when, why, or how the case was lost and concluded their investigation. Are there any questions regarding this matter?
Just a quick question, Tim. Do you know what precipitated the ADA's renewed interest in the old case?
Not exactly, but we know the case was potentially going to court.
And do you know if the loss of the case folder has thwarted his efforts to reopen the case or her efforts?
No, they didn't know at the time when they asked us to re-examine the case.
And I think you said you still had the digital file of the print, is that correct?
Yes.
Any other questions?
Any sense of why it went missing?
That we don't know.
All right. And then finally, this is a non-conformance involving another initial notification of a potential Brady-Giglio issue. Misidentification in casework occurred and was reported and investigated back in 2015. The issue for this notification is that it's unknown if the examiners informed prosecutors' offices of the misidentification and subsequent retraining when testifying prior to their retirement. I just want to note this happened prior to ANAB accreditation, but the laboratory considers this serious and is working to identify cases that may have been affected. Who would like to start with their questions?
I'll start. How did you become aware of this?
So about mid-April, we were made aware by legal that two detectives back in 2015 did make a misidentification, and it wasn't clear if the notification was made.
Okay. And the obvious question is, what have you discovered as to the reason for the 8-year delay?
Say that again?
What, if anything, have you discovered as to the reason for the 8-year delay in disclosure? And by the way, you should be, you were probably in the police academy, so you should be.
Oh, my God.
But you should, I mean, I know we're going to focus on the 8 years and make a big thing about it, but you should be commended for bringing this to our attention.
Thank you.
Initially, so Lieutenant.
Well, my unit, we were made aware in April of this year. And we made our disclosure in June of this year. Although the situation did happen 8 years ago.
Okay, so you're still looking into the reason for the 8-year delay, or?
Yeah, we're still looking at the reason for 8-year delay, but at the time the notification was made to the Brooklyn DA's office 8 years ago, but there was no mass notification in regards to these examiners. And that's when we discovered there was not. We decided to make this notification now.
Yeah, and you, O'Neill, were not in college.
Nor was he part of the latent print section. Neil Fenton from legal. Good morning. When in discussions with the latent print section in or about April, and we found out a little bit more about this, we then questioned latent print section whether or not those particular detectives who were involved in the 2015 misidentification had continued to go to do cases and subsequently testify in court. And the question was posed, was there a universal blast, if you will, to all the DAs, whether or not these particular detectives were testifying in court and whether or not they were aware of that. And that was the reason for the Giglio error, if you will, or the inquiry, I should say, and the reason for this notification.
Wait, sorry, maybe I missed, or were you finished?
No, go ahead.
So sorry, you said you became aware in April, and why? How did it come up in April?
Oh, the Giglio discovery at the time.
Well, the NYPD lab, you can talk about what you were doing in or about April with respect to those particular detectives.
Your question is why did we discover it in April?
Yeah.
We was doing case reviews, and it was discovered that this case may or may not have been disclosed to the DAs at the time. And upon research, it revealed that it was not by the past administration.
Why were you, what do you mean by case reviews that you were doing in April?
One of the examiner's cases came up for court.
Which examiner?
Rex.
Okay. And was this case review at the request of a prosecutor or anyone else?
Yes.
What was the reason they were
A case was going back to court.
right? And they asked you, hey, can you look back at all this detective's cases?
No.
What did they ask?
This particular case was going to court, and since that detective is not available to testify, they would ask us, can you have another examiner review their work so they can testify in that case?
Okay.
And then that's when it was discovered.
Okay. And how, can you just walk us through, okay, so you're getting ready to have another analyst testify because Detective Rex is not available, and he was the original analyst on the April case? Okay. How then did you?
For this 2015 case?
No, for this newer case?
Yes. Sorry, yes.
Okay. And what county is that case in?
New York County.
That was New York County, man.
New York County. How did you find out about the non-disclosure? Does he have a personnel file and it's got a stamp saying he made a misidentification, or how did that actually work?
When we realized there was a misidentification, we looked further and revealed that the disclosure was not made to everyone. It was only made to that specific county.
And how did you know there was a misidentification by Rex?
Through the past administration's notes.
Is that the latent print section notes, or is that legal, or where are these notes kept?
Through the past administration's notes from latent print.
Latent print section.
Latent print section.
The lab administration?
Yes.
Okay. And what I understand from the disclosure that was made was that it was determined that one detective, the original analyst, made a misidentification, and then it was subsequently verified by Detective Rex and Sanabria. How do you know it was a misidentification back in 2015? How was that determined?
Through the notes of the past administration. It was an analysis done, it was researchers brought in, and it was determined that that identification was a misidentification.
Sorry, you said researchers were brought in? Is it
external trainers came in.
I'm sorry, I missed that.
External trainers came in.
And determined it was a misidentification?
So just to add to that response, there was a 2015 misidentification by another detective, Martinez, I believe.
Right.
It was subsequently verified by Rex and Sanabria. Upon the identification, there was an I-card put out for that particular subject, who was, a suspect in a burglary. That was determined that that person could not have done that burglary. As such, that is the basis of the misidentification. There was never any arrest made. The Brooklyn District Attorney was notified of that situation, and then from there, that's when they did their own investigation with respect to that misidentification. And this is based upon, I wasn't even part of this. This is years ago, based upon my review of any records that we had.
And sorry, so how do you know? How did the NYPD investigation determine that it was impossible for it to have been this person's print?
Because the person was incarcerated at the time.
At the time.
I'm sorry, he was incarcerated.
Lucky I have that.
Not incarcerated.
No.
In an institution.
He was in
It
an
was an institution.
not incarcerated.
Sorry, he was in an institution.
Institution.
Yes.
At the time of the crime.
Unavailable.
Is that, I can't say correctional facility, is it?
It was not.
No, it's my understanding it was not, it was a.
Oh, I thought I said.
Mental hygiene institution.
Who in the Brooklyn District Attorney's Office was notified?
Rachel Singer?
Rachel Singer. I think you mentioned a review of testimony by Rex Sanabria and I guess Martinez as well, those three detectives. You're going through past testimony?
What we did was we went through their past cases from the time of the misidentification to the time they retired. And the cases that we reviewed were those who were incarcerated or convicted by a latent identification.
Or a case was brought to the district attorney's office.
Okay. And how many cases have you reviewed?
53 cases.
And what was your conclusion in reviewing 53 cases?
We've just finished our investigation, and everyone is in concurrence with the original examiner. So there's been no misidentifications in regards to these 53 cases.
Who is doing the, well, can you walk us through, I guess, the process of the reanalysis of the cases? Who's doing them, how it's being done, what protocols are being followed?
So we have two examiners who worked on this project, and they were given the entire case, all lifts involved in the case. And what they did was they re-examined the identifications that were made. They used our updated procedures. They did side-by-sides. They did a concurrent sheet. And it was determined that the original identification resulted in a present identification.
So just to be clear, the review is being conducted by other NYPD latent print examiners?
Yes.
Or any of the people or any of the analysts that are doing or have done this review of, sorry, how many cases did you say? 53? 53. Were they trained by Detective Rex?
Those that are doing the re-examination, no.
No, they're all fresh. Okay.
Yes.
Are you also reviewing, I think I heard this, the testimony from Rex and Sanabria and Martinez?
We are not. We are the respective district attorney's offices who have access to the respective testimonies or reviewing them. We have not, to my knowledge, been provided with testimonies on that. But if there is an issue regarding that, then we will obviously bring that to our attention.
Yep, I will bring it to your attention now. We became aware of, and this is just the first couple cases that I've become aware of. This is a federal case in the Southern District.
When you say we, who do you mean?
I mean me.
The commission or?
No, not the commission. I just mean me and other members of the defense bar. Have become aware of testimony in which Detective Rex has testified under oath that he has never made an error in a latent print identification. So I'll read it to you.
This is not part of our commission
Well, it
materials,
is.
though.
I
It's
did not
part of our
materials.
commission
No, not our
materials.
commission material. That's right. I can absolutely share it, but I'll read it to everybody. The question was asked by the prosecutor of Detective Rex. How long have you worked in the latent print section?
What's the date of this, please?
The date is September 13th, 2017. So this would be what, a year and a half after the misidentification.
And what was the name of the case?
It's United States versus Andre Kalix, Calix. So Detective Rex testifies he's been working in the latent print section for about 11 years. He's in this sort of special major case unit. He's asked by the U.S. Attorney, Assistant U.S. Attorney.
Can I stop for just a minute here? Because I'm feeling a little bit uncomfortable about not being aware that something specific about this, you have information that we didn't have. And if I could just ask, since you are bringing it up, is this part of the reason why there was a hesitation on voting to reaccredit the latent print section earlier? So I think that is an issue that maybe we needed to have a little more information prior to having a vote where there was reticence with some of the commissioners, and I don't know if every commissioner knew that the reason why there was reticence is because you had information that we weren't.
Well, I think the vote was on the ANAB.
It was,
Right.
but we did have discussion about whether we should even be voting because you wanted to wait on voting because you wanted to have this discussion about these disclosures. And now, I don't know. I just want to express a little bit of discomfort in having this brought up in this way. Maybe it's right, maybe it's okay. I don't know. So
I want to echo her discomfort in the fact that what you're bringing to the table is not as a commission member at this time, in my opinion.
No, it is as a commission member.
No, it's as
Well,
you
it's not as a
received
commission
these-
member because the other commission members have not been made privy to the information that you have. They can't even ask questions on it because they don't know about it. So it's kind of like an unfair
I'm happy
advantage to the
share
rest of
it,
the
but
members.
I disagree. This is my job as a commission member. I have become aware of
But you didn't
Detective
share it
Rex
with
saying,
the
and I'm
other
going to say it
members.
before I get shut down by the rest of the commission. Have you ever been found to misidentify a print? Answer, no, I have not. This is after the 2015 misidentification. That is under
Wait a
oath
minute.
in a federal trial. It is not the only trial at which he testified this. This is
Jessica,
a
I
huge
understand.
issue.
Let me interject here for one moment in the fact that I don't know the source of this material as no, wait
It's public
just a minute.
record, but
Wait
sure.
just a minute, as none of my other commission members know, correct?
And can I just cut you off for 1 second, Jill, as well? In other instances where you have, and I don't mean this as pointing a finger at you, Jessica, but
No,
you
it's
have,
fine. I'm
you
used
have
to it.
been very, but you have been very, you've shared with Office of Forensic Services some other items where between meetings, you've provided information for us to be able to review prior to the next meeting.
Sure,
So,
absolutely.
let me ask you a question. When did you become privy of this information, and could we have at least gotten it with late documents prior to this meeting?
What I just read, I got yesterday.
You got yesterday. Okay, so you
So that's
literally
where
was
I
hot
think I
off
need
the
to
presses.
interject and say that it's fine. It's providing it to the commission members and making the lab aware.
Yes.
So that they can speak to it also in a prepared fashion is fair.
They said, you were very clear that you haven't reviewed testimony, so I understand that. But what I am doing is bringing to your attention that there's a serious problem here.
Sure, and we would
And
like to.
I understand you can't respond on the fly, you don't even have the written documents in front of you, but I am bringing this to your attention.
Right,
that
nor
there's a
was
real
any of
issue
the
here.
parties who were present here involved in any of that. So that said, we would need some time to review the documents. and-
absolutely.
and if they can answer questions, then they will. If they can't, then they won't.
Sure, absolutely.
I also would like to point out that the time of this testimony and the time that this case was prosecuted and the time the examination was done does not fall during the time that the commission would have had oversight on them.
But the commission has oversight now about how NYPD latent print lab is going to deal with this situation. A situation where we have serious concerns that the detective is misrepresenting the truth, right?
Yeah.
So, and I know you haven't seen that, but our jurisdiction right now is how, and I understand you're inheriting these issues, right? So that's a lot to deal with. But it is a critical part of being an accredited lab and one that's, abiding by best practices about your duty to disclose and rectify errors. And I know that is what you are working on right now, but that is what we have oversight
And as
over.
part of our continuing duty to disclose, we have that upon realization. So that's why we're here with this notification.
But again, just want to, and I'm so sorry, Neil, to cut you off, but initial notification of this investigation where I heard, and correct me if I'm wrong, other commission members, that they are not reviewing direct testimony, rather that is falling within the district attorney's office for the testimony to review on the cases that were potentially impacted, and then they would be notified, right? So they haven't reached that stage yet. You've brought something to their attention, which, they may have come to a conclusion on that before the next meeting if that were the case, then we would have heard that, they would have submitted documents, we would have reviewed that. Or, sidebar, you would bring it to our attention, we would provide that to the commission members as a whole, we would share that information with the lab, they're legal, so that we could add to their investigation, make that a part of it, and then speak on it. But everyone would be aware of it. And I think that's just where the issue that I'm having is that you're aware of this information. I don't think that we can bring that into this conversation at this time without everyone else having a look at it, knowing where it's from and knowing the context in which it's coming from.
Delighted to share it, but I think that given the disclosure that we did get in our materials, that there is sufficient information here to ask, as DA Fitzpatrick led off with, what on earth was going on, right? What on earth explains the 8-year delay, and what are you doing about it? I'm curious why you aren't running to check the testimony of the examiners that, and we, you know, he says he's testified, what, 27 cases or so, and that's as of 2017. Why wouldn't that be a process of your review?
Because we're re-examining the evidence.
Okay. And have you considered consulting with someone not affiliated with NYPD to do a scientific technical review of the evidence?
No,
Why not?
because my examiners are capable of doing it.
Does the commission, here's a question, does the commission have the authority, the capability to require the NYPD latent print lab to consult with independent latent print examiners to do a review?
Of what? Of the cases?
Of the old cases, yes. We don't know.
I don't think so. I don't. It's part of their quality system. They're working within the confines of their quality management system, which is to have the review done by who they assess to have the review done by. They're not doing anything, I think, that is egregious that would require.
We don't know, I guess. Maybe not, but we don't know. Would you be willing to share the, do you have sort of like a written plan for how you're conducting this review?
Right now, this was a notification, and we are going to be closing this matter out with documentation. And if there's specific things that need to be brought to your attention, we can absolutely do that. As we said, the process right now is the notification. We wanted to answer the questions upon the notification, but there are further internal meetings we have to discuss about what's the next step. Is it closure? Is it further examination, etc.? And based upon information you just supplied with us, we have to take that back and discuss that. What actions we need to take in that regard.
I think one of the concerns is it, well, let me ask, Detective Rex was a trainer of other latent print examiners, right?
Yes, he was.
And from the testimony that I'm happy to share, he was the sole instructor for some manner of time?
Yes, he was.
What time period was that?
It was after the misidentification.
What time period was he the sole instructor of other members of the latent print unit?
From about 2017 to 2019.
When he retired?
Yes.
And I understand that you've done a review in-house of the cases since the misidentification in 2015 until the retirement of the two verifying detectives. What about pre-2015 when the misidentification happened?
The previous administration reviewed cases from the time of the misidentification to the time they got into the unit.
Yeah, I think the disclosure mentioned that. Has there been any discussion about whether you're going to go back and relook at those?
No, we're not. They were previously done.
So you're confident in what the previous administration had done in their review?
As we said in the notification, the previous administration chose to use external consultants. If you saw that, they chose to use external consultants at that time.
To do the actual case review?
To do the retraining.
Okay, just the retraining,
Yeah,
but not the actual case review?
I don't believe so.
Okay. Who were the external consultants that did the training?
It was Glenn Lannenberg.
I think we have a question in Albany.
Yes, good morning, thank you. Just a quick question. It's nice to hear that you're re-examining the evidence with your current SOPs, and I'm sure you have the competent analysts that are looking at them. I just have a question. The analysts that are doing the reanalysis, are they aware of what the original findings were? Or are they looking at the evidence without knowing the originally reported findings?
They were aware that an identification was made.
I'm sorry?
They were aware that identification was made.
I see. Are they only reviewing the cases in which identifications were made, or are they reviewing all of the cases?
Cases in which an identification was made.
Okay, thank you.
Any other questions in Albany? How about here?
I don't have a question, I just have an observation. I think Jessica's point is a separate track from what we're doing. Obviously, competent defense lawyers are going to examine this guy's cases, all three of them, and make decisions. I don't want to convict Mr. Rex of perjury at a Forensic Science Commission hearing without giving him an opportunity to explain that testimony. If I was his defense lawyer, I could easily explain that, but that's not my job here today. And I think this contingency from NYPD, as I tried to make clear at the beginning, should be commended because you brought it to our attention. You could easily, this could easily have been just, it's 2015, it's 8 years ago, let's forget it. So I just think the question of whether or not Mr. Calix, as well as other individuals, get new trials is a separate track from, are these people doing the right thing, notifying the right people, and making efforts to make sure it doesn't happen again?
What efforts are you doing at notification? I'm also a defense attorney, obviously, and we did get from, I think we've gotten them now from all 5 boroughs, if I'm not mistaken, district attorney's office, with the disclosure letter, I think your disclosure letter. So we have received that. What other efforts have you made? For disclosure, is that it? You notified the DA's offices, and when was that?
In June.
In June, okay. And then we received, I think, notice in late July.
And in the respective follow-up with the district attorney's offices, that those notifications have been made and that they have in fact turned over to the respective defendants.
Have the district attorney's offices been, no, scratch that. Can you explain what the verification process was at the time the misidentification was made? Is it the same as it is now? Okay. How did it differ?
So the verification process now is much more robust. The verification in 2015 was a bit less.
Mm-hmm.
The verification process, the second examiner, they would fill out an identification form. They would make they will plot the lift that was the ID, and then they would do a screenshot of that, and they would fill out the ID form with the lift identification, and that's it.
Sorry, I'm just trying to visualize it.
They had an LPS form,
yeah,
that they filled out,
mm-hmm.
and they did minutia points on the lift that made the ID, and that was it.
So it wasn't a full independent review? Is that what you're saying, by the verifier?
There was 2 verifiers. The second verifier did the full review of the entire case folder, which was known as a tech review. And they also themselves made minutia points on the lift that was a positive ID.
Did you disclose this issue to ANAB during the accreditation process, prior to accreditation?
No.
Why not?
Because we were notified about this in mid-April of 2023.
And when you say we...
The latent print section.
The latent print section. But you don't know if anyone else in NYPD was aware of this?
No.
Thank you.
All right, thank you. We'll move on to the New York City Police Department. Again, this is for informational purposes. No vote is required. This is a notification regarding a proficiency test where the lab did not report the intended results. ANAB acknowledged the receipt and asked for additional follow-up information, which the laboratory has provided. I think it's easiest, Scott, if I just call you to the table, just stay at the table. I don't know if Stephanie.
I think Stephanie and Nicole, if you don't mind.
Okay,
Just in
come on
case
up.
there was more technical
Yep.
questions. Thank you.
I'm gonna do a really bad job of explaining this, but I think, so with this proficiency test, 15 individuals at your laboratory took it,
Yes, so
12
12 did not
did not get the expected result.
results. 3 of them did get the expected result. 3 of them did identify a controlled substance. 12 did not. So their report that was issued was no controlled substance identified. We received from the external provider the result, the expected result, which was a controlled substance. So we have a notification to you today about that. What I would like to bring to your attention, of course, hearing 12 people did not get the expected result, raises some questions. What I'd like to bring to your attention is this is not analyst driven. This is the policies and procedures of the laboratories. This is not analysts. The analysts did not, in my opinion, and I think once you hear all the information after we wrap up the investigation, is that it's not analyst driven. We have policies and procedures that the analysts follow, and based upon the procedures they followed, they did not get a controlled substance. Some of you may recall this happened previously in 2016. I think I was on the commission at the time, but we had 10 examiners were issued with a proficiency test, and none of them identified a controlled substance. And I brought that to your attention. And then unfortunately it happened in 2011, where there was one individual had an external proficiency test, and they did not identify a controlled substance. And each of those instances, 2011, 2016, and this year are not analyst driven. It's based upon the policy procedures of the laboratory. Sorry. No, I didn't. And we're still doing the investigation. We recently just wrapped up testing the proficiency test to see if it does contain the controlled substance, and it does.
Have these analysts ever been given substances that don't have any controlled substance in them and they come up with a controlled substance? I mean, do you ever do the proficiency test in the sort of the opposite direction?
We have different proficiency tests. So a proficiency test can come from an external provider. So in this particular one, there was 2 items. The first item was a controlled substance that we did not identify. The second item was a non-controlled substance, which in these analysts all identified a non-controlled substance. I can't speak to all 15 people. Some of them this might be their 4 year of their career, or maybe a 20-year career, and what happened in different proficiency tests. But what I'd just like to make clear is what happened in this particular proficiency test is they followed the SOPs of the laboratory, and in 2011 and 2016, we brought this to attention to our customer working group. We brought this to at that time, ASCLAD Lab was in 2011, which they had a proficiency review committee. And then in 2016, we brought it to ASCLAD Lab again. And the resolution for us was, unfortunately, this is a cost of doing business in a high volume laboratory, that we can't guarantee that we're going to identify every single controlled substance in every form based upon our needs to meet certain parameters, such as 180/80 and other factors. Of course, now we're going to look at it again because, this is in their proficiency test results and discovery. It says, did you get the expected result? No. and they're going to now have to testify to what happened in their particular cases. So we want to make sure that we're giving fair tests. But this, what failed here, if you want to use a failure, is the system, the policy and procedures of the laboratory. And in 2011, 2016, we decided this was acceptable. Whether in 2023 we decide it's acceptable, we're still doing the investigation.
So, Scott, the problem you're suggesting is not the individuals, the 12 individuals. And I have to, knowing you, and I'm biased, knowing you, I can't imagine that these aren't competent professional people. Might the problem be with the method of analysis and or the sample itself?
Correct.
And you're still looking into that?
Yeah, I mean, we feel we know because we had this issue in 2016 and 2011. There's certain, I don't know why I specify the particular controlled substance, because someone could then start using that controlled substance in a form that we cannot identify, but certain controlled substances require different levels of sample preparation. And we do our sample preparation based upon the form that we receive that sample. So we've discovered that our procedures are set up in a way that if you do a certain thing with a certain controlled substance, it's possible it would go through our laboratory system and it would not be detected. Does that make sense?
It's the same drug from 2011 and 2016 you're failing to detect?
It's the same drug from 2011 to 2023.
Mm-hmm.
It's a different drug in 2016, but falls under a class of drugs. Again, trying not to be too specific, but there are certain drugs are grouped together.
Mm-hmm.
These three drugs are all grouped together. And we have identified these drugs. Sorry.
I'm just wondering what if you're aware of what the concentration was in the proficiency test, and if that's close to the limit of detection, what your validation of the method has given you?
Well, it's not below our limit of detection, it's below the way we prepare our samples, because what I was going to state was we can identify these controlled substances regularly. It's not like we don't identify this controlled substance, but it's in a certain form that gives us information. So we go down this path and we can identify it on the instrument. But with the information we have now, we go down this path, and based upon the way our procedures are set up, not the annals, procedures, we might miss it. And in this instance, you can see we missed it 12 out of 15. Just to be clear, but the three people that did identify it, they ran it on an instrument and they saw indications of a controlled substance. It wasn't like, oh, here it is. They saw indications, and that led them to do further testing, and that led them to make the identification. So this is a weakness that we know is in our system since 2011, which our customers have been aware of since 2011, 2016. We updated them recently at a meeting last week. Our meeting last week. We updated them again, but we're in the process. Like this was just a notification. We're hopefully wrapping up before the next commission meeting, and maybe we change our policies. Maybe we don't. We really need to look at the system today, because those decisions we made in 2016, the world has changed in 2023, so we need to see if those reasons are still valid.
Scott, I have a question. Thanks. So I just want to make sure I understand. So the 15 people who took the proficiency test followed the same SOP and used the same sampling plan or standardized sample or whatever it is you use for powder substances. The three that did get the expected result used a different instrument than the other 12, and there was an indication.
Well, so one of the things is unfortunately with the lab, the NYPD lab is scale and scope. We have most labs maybe have 2 or 3 GCMSs. We have 40. So people use different instruments on different days. So we did notice that some people used one instrument on one day, one instrument another day. Maybe have used the same instrument. What we're leaning towards, and we haven't completed our investigation, is that it's possible that the other 3 just happened to have a better representative sample that they tested. Mm-hmm. And again, what I want to indicate is they had indications of a particular controlled substance, and that allowed them, based upon the policies, to go back and take more than we normally would. And based upon that, they were able to make an identification.
So 3 resampled and the rest didn't.
Yes, because they follow their
They
procedure.
follow the procedure.
We're very clear procedures of how far they go. We do this, and then we stop. We don't go do this, and keep looking. Right?
Right.
And I think, Judge, to one of your points is, I think this is also, I'm glad to be here to talk about it because those examiners had an external PT. They know they've got something.
Right.
Most external PT providers don't provide you just non-controlled substances. So they chose, they stopped where they were supposed to stop. They stopped where they were supposed to, and the others, they continued because there were indications. So in my opinion, the process worked, but unfortunately, I don't want it to be attributed to the analyst.
Right.
They'll have to answer out
Right.
because their PT is listed in the discovery records. They'll have to answer out, but again, I think it's definitely the system here. As the lab director, this is the system I've allowed to happen in the building, in the section.
Again, I'd just like to ask, in your validation of the method, with this, did you show that at these levels it should have been detected?
Yes, with the correct sample preparation. When I mean correct, let me rephrase that, with the sample preparation based upon the right information at that time.
And was that not part of your validation, the sample preparation?
No, because that particular sample preparation we feel is being conducted by the provider, which is not what is going on in the public domain. That is not how those particular controlled substances are being utilized or distributed. So we did not consider it as part of it. We did consider it in 2011 and 2016, but the cost-benefit analysis of us chasing after this one particular controlled substance would require us to do additional testing on a lot more cases to make sure we weren't missing certain controlled substances.
Scott, is that because alprazolam typically comes in tablet form, and so the concentration is much lower in the tablet form?
So since we've already mentioned it, yes. So we can identify alprazolam tablets. And if I can ask us not to talk about whatever form the proficiency test was in, but we can identify alprazolam tablets because it's a tablet and we prepare it and we run it on samples. But if you change the form of it, it may not be detected.
Okay.
So now we're giving tips to drug dealers in Manhattan. Is that where we?
All right, any other questions?
I don't think they read the minutes.
They don't watch this.
They're watching YouTube right now, Judge? All right.
Based on seeing how many people watch our YouTube, there's not that many.
No. Hey, no.
I'm sorry. They don't know what they're missing. It's good stuff. Quality stuff goes on in these meetings.
Amen.
It is.
Any other questions for NYPD before we release them? Okay, thank you.
Thank you.
Thank you.
Thank you.
So
Good to see you.
we normally don't do this, but we are going to take a brief break. First of all, for those of you who don't know, in Albany, we need to thaw out a little bit. We're a bit frozen. I can't feel my toes right now. So we're just gonna take a brief couple of minutes. We're just gonna mute. We're not even gonna stop the YouTube live feed, so that way folks know when we come back, in terms of those that are viewing. So please mute, go, run. We will be back when everyone's back in session. Thank you.
Okay, sounds good, thanks.
Okay, everyone, we are back. We'll continue on in the agenda under lab disclosures. Our next up is the New York State Police Crime Laboratory. This is for informational purposes. No vote is required. The first issue is regarding a CODIS notification letter that included an incorrect name. ANAB has acknowledged receipt and requested updates when available. The second issue involves a closeout of a nonconformance where seized drug evidence was also submitted for DNA testing. However, the analyst was not aware of that additional testing request. The original notification was presented to us back in the March commission meeting. The laboratory now considers this event closed. Are there any questions for the lab regarding either of these events?
Yes.
If we could have the quality assurance manager come to the table in Albany, I believe. Dave is there in Albany.
Yes.
Good morning. Okay,
It's still morning.
Yes,
It's still morning.
Good
Good morning. My first question is about the wrong name being released in a CODIS hit. I understand you're still in your investigation, but have you preliminarily determined the cause of this error?
Yeah, actually, we're in the process of closing it. We're just waiting for the lab director to actually sign off on it, then we'll be forwarding that through. But we identified two areas, two causes. The first one being the review process, the admin review process didn't specifically require a review of the name that's in the letter itself. The admin review checked other things, but not that. So now we corrected that to, now there's a step in there, a positive step in there to actually verify the name that's released. Secondly, the CODIS administrator, when we were speaking to her, mentioned that she just was feeling overwhelmed with a lot of work and she felt kind of pressure to get stuff done. So as a follow-up to that, both that administrator and the other ones, they were reminded to, if they feel overwhelmed, sit down, talk to their supervisor, and then maybe we could make some kind of adjustment in their tasks that they're assigned to at that particular time.
Does anyone else have a question on that one?
Nope.
The second question was with respect to the item that was submitted, I guess the pills and the baggie, and the analyst didn't notice that there was a dual request, one for the seized drug analysis and the other for DNA testing of the packaging. Is it correct that, so the analyst, the drug analyst didn't follow the protocols for certain decontamination procedures or contamination protocols where they'd be extra, I guess, protective to avoid contaminating any potential DNA evidence? Is that right?
Yes, the analyst was missing some of the PPE we require for an item that is known to, that we know is going to be going on to, for DNA testing.
What PPE was missing?
Well, like, maybe a hairnet, I don't know.
The hairnet and the face mask.
Yeah, hairnet and face mask.
They were wearing gloves.
Wearing gloves, a lab coat, worked in the fume hood on clean butcher paper.
Has the packaging since been DNA tested in the case? I'm sorry if I missed that in your disclosure. But
it was.
Was the DNA profile of the analyst provided as a elimination sample?
Well, the mixture, it turns out that the testing on the baggie, the mixture was too complex for any usable information, which is not uncommon for that type of evidence anyway. So
does the lab regularly? So I'm sorry. Go ahead.
I was just going to say, I actually forgot what I was going to say. It's not uncommon for that type of evidence to be so complex that we can't do anything with it.
Do you regularly test drug packaging for DNA?
Occasionally, I don't know, Chris, how many?
When requested.
Yeah, occasionally.
Thank you. Any other questions? All right, thank you all.
Thank you.
Next up, we have the Niagara County Sheriff's Office Forensic Laboratory. This is for informational purposes. No vote is required. This is a, was initially submitted to us as a closure of a proficiency test issue first identified in January of 2023. The quantitation results for fluoxetine were outside of the acceptable range. The laboratory has determined that there were multiple factors that may have caused the unexpected results and has implemented some corrective actions. Our late documents showed also now that the laboratory has since reopened this corrective action, and you have those available. So it is now reopened. Do we have any questions for the lab? Can we get Christine on? I believe she's on the phone. I see a box, but I don't see her. There she is. Christine, can you hear us okay?
I can hear you, yes.
Okay. Pat, I think you raised your hand. You had a question?
Hi, Christine, good morning, or late morning. So the question I had, based upon this, and I want to make sure I get this correct here. I believe the drug was, oh boy.
Fluoxetine.
Lydia, help me here.
Fluoxetine.
Fluoxetine. And I didn't do my research on the drug itself, but what the question is there is a reference from a text, and I'm assuming it is obviously a text that you reference to on a normal basis. And I guess the opinion of the medical examiner that regardless of the 44% deviation, right, you got the new standards and you saw a 4 times increase in the signal. Did any of these cases go to criminal trial? Because I guess not sure or not.
No, they did not go to criminal trial.
No.
Okay. I guess the only opinion I have is, and again, it's my opinion, is understanding that there are reports that went out with the wrong concentrations, and I understand in the world of toxicology, it might not be important. It's just, and again, it's an old case. It's before ANAB, right, ABFT. I'm just looking at the optics where it's like, well, we know we have these issues, but because there's no effect on casework, we're not going to look into it and we're not going to rerun. So my question is that obviously that's a discussion with the chief ME and so forth, that your customers are content that they know that there are reports out there that have lower concentrations that should be reported.
So we would rerun. We did actually rerun to know that particular case. There were actually 2 cases that were affected. One was within acceptability, and it was really the other one that had been impacted. At the time, we had not reissued a report, but again, you know, I've reopened the case because upon examining a second failed PT result, it called into question some practices that were ongoing. So I wanted to examine all the methods comprehensively. We do not, so there were a number of factors that I believe influenced the first failed result. And, we will definitely revisit whether we need to reissue final reports with the corrected values. And we definitely would if we felt that the cause of death would be altered with any results. So for instance, if it were a drug overdose and an opiate were involved, this is an antidepressant that had no significant impact on that particular case.
Okay, understood. Thank you.
I'll just trot out the soapbox that I often get on, which is, from your perspective, it may not make a difference, right? But from the legal perspective, it might. And in the hands of a defense attorney, it might be important information. I think you should issue the amended report. I wanted to clarify something. Did you consult with a medical examiner about, because I see in the paperwork that you did provide that you say the 44% deviation of the reported fluoxetine level would not have any effect on the cause of death. So no amended report was issued. Who made the determination that it would not have any effect on the cause of death?
My section supervisor made that determination. I am unaware if she consulted the chief medical examiner in that case or not.
And she's a toxicologist?
Yes, she is.
Right. I mean, should she really be opining on cause of death? I understand you consulted, reference manuals and whatnot. That would just be another reason to issue the amended report.
Okay.
With that level of deviation. I also noticed in the disclosure, you found in your conclusions section that you did not have validation documentation for some of the methods that were being used. Could you speak a little bit more? Is it multiple methods you don't have validation for, or just this one quant method? Could you just explain that?
Sure. So we have several methods that have been used historically. They're probably over 10 years old. And so we have limited documentation on it. That's why one of the reasons that, that when I started this position, I made the determination that we needed to do significant revalidation of our methods to bring all of our methods up to current standards. And so that's an ongoing project that we hired an outside consultant, and we are in the process of doing that revalidation. We do have some documents. Fluoxetine happened to be one that was put into a method, we believe, at a later time after the validation. And so there was limited validation done of that particular drug. So that particular analysis does many different drugs. I forget the exact number. I think I did reference it in the write-up. But that one, again, was added probably after the fact. And so we just don't have the documentation, or I am currently unable to find the documentation. I do believe that they were validated according to their procedures at the time. I have found LCMS method validation templates that were used. It's just everything is in paper, and trying to find some stuff is a little challenging.
Yeah, I think one of the themes today is inherited problems from predecessors for sure. But it sounds to me what you're saying is that casework is being analyzed with methods that you're not sure were validated, or at least you don't have documentation for. Is that right?
I do not have the documentation for it. I am currently in the process of reviewing every single analytical procedure that we perform to ensure that our data is accurate and reliable, and I'll be taking out of service and be making a separate notification to you and our customers should I deem any analysis not up to be robust and reliable.
I'll rely on fellow commissioners, but if you don't have evidence that the method's been validated, don't you have to stop work? I mean, isn't this, if you can't prove you validated the method in the lab, don't you stop work?
Our validation is necessary to get your initial accreditation, so you would have to have that documentation. But I defer. the lab director. I don't know.
The method itself has been validated. That means, that the drugs that were validated, but since that time, additional drugs have been added to that procedure with less validation criteria. Again, no validation criteria existed at the time. It was developed in-house. And so I'm just unable to locate the documents for this particular drug.
It's part of,
Yeah, I don't understand.
go ahead.
I don't understand what you said, that none existed, and so the lab had to come up with standards? Is that what you said? I'm sorry.
So there were no best practices in the field of forensic toxicology until Swig Tox produced a method validation document a number of years ago, and that's since been updated and published as an OSAC standard. So that is actually now a method validation standardized document that the forensic toxicology community is adhering to. And that is one of the goals of this laboratory, to bring everything up to modern day procedures, in modern day protocols.
Thank you.
So they
Who's the
had
consultant?
Her name is it's called Toxicology Solutions. Her name is Carol C.
Thank you.
Good.
Go ahead, Fred.
Good.
And then we'll hit Albany.
Director, I just, looking at the conclusion portion of the report, this page 170 for fellow commissioners, be page 4, and under conclusion item number 1 and the subsequent 2 subsections there under 1, you talk about stress, and there's a portion here where I just wanted to read, in reference to the stress, quote, "This is anticipated to get worse as they know that any drug not detected, quantitated, must now be reported to ANAB and DCJS." By DCJS, I assume you mean the Forensic Science Commission. But my question is, my question is about the word "now." That suggests to me that prior to now, those things were not reported to ANAB, or am I reading too much into the word "now"?
So prior to the updated AR 3125 coming out from ANAB, if a drug was not part of the analytical scheme of a forensic laboratory, it was okay to simply report it qualitatively and state that it was not part of our analytical scheme. We do not quantitate this drug, and that's a document that we would keep in-house and they would inspect on site. Now ANAB has changed their policy to state, because we perform that any toxicology laboratory that performs quantitative analysis, if they do not quantitate every single drug in the Proficiency, that it must now be disclosed to them, and then subsequently, because we're informing ANAB, we must subsequently inform DCJS, the Office of Forensic Sciences. So it just makes, they feel like it brings increased scrutiny for drugs that we do not currently do in-house.
So just to clarify though on that point, I just want to make it known though that it has always been practice that every laboratory has to make these disclosures to the DCJS, i.e. the commission, regarding any issues with proficiency tests. That is a portion of your required documentation for your annual lab summary. Whether or not it reaches the heightened level of coming to the commission is based on thresholds that were set. So if your laboratory did not test for a particular drug, and so an unexpected result was received by the analyst, that would go in your annual lab summary, because that's something that is maintained within your quality management system. That is not something that would need to come to the level of the commission, but would be reflected in the annual lab summary, which is also provided. So I just want to say that whether or not your analysts were aware of this beforehand or not, this is practice that has always been happening. I want them to be rest assured we are not here for the I gotcha moments. We are here to just ensure that there's quality work being done across the state. So I just want to make sure that's clear and on the record.
So prior to 2023, a failed proficiency exam in the Niagara lab would have been reported to ANAB or ASCLD lab in the distant future, in the distant past.
Yes, absolutely. Anything that was rated unacceptable would absolutely be disclosed.
I would just like to add to what Jill said. Our staff goes through every proficiency test result for every analyst in every lab every year in the state. We get those documents, and it's a time-consuming thing that we do at the quarter one of it.
To deceive anyone, and I can certainly understand how that might cause stress. I have to say, though, I've never seen that as given as a reason before, and I'm wondering if recent developments, Director, have added to the stress of your analysts in your lab?
With respect, sir, you have no comprehension of how the stress has increased in this laboratory since March.
Okay, well, I don't know why you would take umbrage at me for that. I if you tell me about it, I think I'm a homicide prosecutor by profession. I think I know what stress is, but in any event, I've never seen that before. So I hope that you're taking matters to alleviate that stress, and anything we can do to help would be. I think Jill has said that more than once. Last question. It's under 1. It's on page 171 for my fellow commissioners. Page 5 of your conclusion, Director. While they have always had the power to do so, stress that the same care with proficiency testing samples must be taken as with casework samples. I'm not sure what that means. Maybe it might have been miswritten. But the follow-up, results do not need to be reported to the provider if uncertainty exists. So could you clarify the first sentence, and then tell me what you mean by the second sentence? Who is the provider, and why do the results not need to be reported in that example?
So, building on what I had stated in the first point, where they now they are aware of this requirement that it must be reported to NAB and subsequent to the commission, and they feel that we are under scrutiny. They feel that because a drug is on our scope, that we must automatically do everything we can to quantitate that drug, instead of taking a step back, evaluating the data as a whole, taking a pause, and figuring out when something's going wrong, which is why they were running it repeatedly, trying to get an answer so that they could get it by the deadline, instead of calling attention to the fact that there was an issue, bringing it to me so we could sit down and discuss. So my caveat to them is, if it's reported qualitatively and we send it to you guys, send it to, to DCJS and the Office of Forensic Services, then it's, that's going to be a routine part of our work. But because this is something new, and again, they feel the increased stress, they were trying to get results.
Christine, do they feel the same way with casework?
So one of the things that I have been really taking great care in is to make sure that they are doing things consistently, regularly, and not feeling that stress as much as possible. To do that, I've been open and honest and sharing with them as things develop and as things happen. You know, I include them in conversations. They feel the stress when it comes to the increase in the overdose deaths. So that's definitely something that they have to, you know, stop and take care. But they know that, you know, there's relief in sight. Let's put it that way. That we're going to have new methods that are going to be done. That we've got some automation that we're validating to help with their ELISA test screen. And I'm really proud of the way that they are handling things. They are stepping up to the plate. They are doing things exactly as they should be. They are following existing protocols. They are documenting everything, and I'm very proud of my analysts.
Now, Christine, I'm sure you are confirming with them, and your new QAO is going to be working with them as well to make sure that they are following the policies, such as proficiency testing samples should be treated identically to any other sample and should not be rerun in such a manner.
Well, I understand what you're saying. Thank you, sir.
I have a question. While they were doing all this rerunning, it sounded like you weren't aware of this. Is that true?
That is correct. It was handled by my section supervisor. And, you know, a routine failing of a control is something that is not brought to QA's attention. They know that they report everything qualitatively, that any additional analysis can be performed. It was just when it was happening repeatedly that it should be brought to my attention. And, you know, they, again, especially since March, have been a little protective of not trying to overwhelm me.
But they eventually came to you? Or have you had a conversation with them about talking to you more routinely about issues like this?
Absolutely, and we're initiating weekly meetings with the entire laboratory so that we can sit down and have regular discussions to know exactly what's going on in every section.
Great, thank you.
Thank you.
So Christine, when you reopened this, it was a new PT or was it a case-related concern you had?
No, it was a new PT, and what I'm doing now is evaluating all of the quantitative methods to make sure that cases are not impacted.
Okay.
Any other questions? Excuse me. All right, thank you. Moving on, we'll now go to the Suffolk County Crime Lab. This is for informational purposes, no vote is required. This is actually a closeout of a non-conforming proficiency test that was first discussed at our December 2022 commission meeting. The lab now considers this event closed. Are there any questions for the lab?
Just one.
For the lab?
Yeah.
Can we get those folks, they should be on the phone virtually, I believe. I'm not sure if it's going to be one screen or several screens.
Morning.
Hi, Inga. Is everyone there with you? Oh, okay.
Yes.
Yes. All right. Hi, Connie. Couldn't see you there.
Why are you hiding?
Right. We have Inga, Connie, and Don. Go ahead, Don. Tom.
Thank you. Hi, good morning. Just a quick question. Why make the decision? I saw in your materials that you actually haven't had a tire impression case in the last 10 years when you went back and checked. Why are you still doing them?
So this is part of our scope, and as management, we feel like we don't want to take anything off our scope just in case a case does come in where we do need to do that type of analysis.
In addition to that, our crime scene response team is still continuously collecting tire track samples at a crime scene in the hopes that a known vehicle would be submitted to us for comparison purposes. So we do have evidence coming into the lab that could be compared to a known vehicle.
Thank you. Anything else, Albany? No? All right, thank you.
Thank you.
Thank you.
All right, moving on, Suffolk County Toxicology Laboratory. This is for informational purposes. No vote is required. This is a notification of a non-conforming event, the investigation and closure of said event. This involves 5 amended post-mortem reports for incorrectly underreporting the quantity of THC alcohol. The lab has investigated the event and made corrective actions, and the lab considers this event closed. ABFT has reviewed and approved the action taken. Are there any questions for the lab? I'm not sure if we have a representative or not.
I did have a question for the lab, if they're here, if not.
Shelley, did we, I don't know if we ever got an RSVP from them.
We did, very late breaking. Dr. Lair and Ed Minden should be available.
Okay.
Or.
Brianna, if we can elevate them.
It should be with Inga.
Oh, different lab.
Oh,
Suffolk
he's there.
Tox. Suffolk
Yep.
Tox.
But he's there.
Oh, he's there.
Okay.
Good morning.
Okay.
Good morning. Good morning. So I understand you changed your procedures, and you're no longer using, I don't exactly understand what this is. Maybe you can explain a negative blood matrix sample. What could you just explain what that actually is?
Sure. We utilize negative blood from the New York Blood Services as our material matrix for calibrators and controls. In this particular case, this one negative blood was positive for a low amount of carboxy THC, which we had set aside and labeled appropriately to be used for only specific analyses that did not involve these types of drugs.
Is there any potential, or have you checked to see if this would affect any other kinds of drugs or just THC? Because
Well, yes, as part of our validations, we do check other drugs within those individual validations. So if there were a compound that was present in one of these negative drugs, negative matrices, we would not use it for that.
Okay. So you're confident that this isn't an issue with anything but the THC, and you took steps to change your practice to fix the problem?
Correct. It was only THC that was present.
Okay, thank you.
Any other questions? All right, thank you so much.
Thank you.
We'll move on to the Westchester County Department of Labs and Research Division of Forensic Science. This is for informational purposes. No vote is required. This is a closure of the event that was discussed at the June meeting regarding unauthorized access to the laboratory. The lab has investigated the event and made their corrective actions, and the lab considers this event closed. Are there any questions for the lab? All right, Westchester County Department of Labs and Research, Division of Forensic Toxicology. Informational purposes, no vote is required. Ditto, closeout of an unauthorized access to the building. The same documentation is submitted by the Westchester Division of Forensic Services. They consider this event to be closed. There is also an initial notification and closure of an incident where a draft report was issued as a final report. The laboratory has conducted an investigation and considers that event closed as well. Are there any questions for the lab? All right, hearing none. Yonkers City Police Department Forensic Science Laboratory. This is an initial notification for informational purposes only. No vote is required. This is involving an analyst not following the SOP. The analyst did not test all items of evidence within a case to reach the highest potential charge. The laboratory has investigated and begun a corrective action plan. ANAB has also been notified, so we will see additional information on this once they have completed their investigation and implemented their corrective action plan. Are there any questions for the lab? Yes. All right, if we could get Christina and Crystal elevated. All right, I can see the box, and she's unmuted. There they are. Hi, Christina. Hi, Crystal. All right, go ahead. Are there any questions?
Thank you. Hi, good morning. I understand your standard operating procedure says the analyst will analyze to the highest charge. Could you just walk us through how that happens? How would an analyst make that determination?
So based on the evidence, the analyst will, the way it's submitted, the analyst will determine which initial units to analyze to confirm presence of a controlled substance. And then based on the size and weight, that would determine how much to analyze to reach the highest charge.
Sorry, I'm just having trouble with the reference. So can you just give me an example? Is this a situation where you get 20 baggies in and you only test one or something, but they should test all 20? Can you give me an example to sort of illustrate it?
Yes, for an example, if there is, we can use your example, if there's 20 baggies and the analyst sees it, they can kind of take an estimate to see if a certain charge or the highest charge. If based on their estimated weight, if they only have to analyze one baggie, that's what they would do. If they do an estimated weight and discover they have to do multiple baggies, then they would ultimately analyze multiple bags.
Okay, thank you.
Any other questions? Albany? No? All right, thank you so much. All right, we're moving into the last part of our agenda, potential executive session. Do I have a motion to go into executive session to discuss matters relating to a current investigation or matters that may lead to the appointment, promotion, demotion, discipline, or suspension of a particular person?
So moved.
Fitzpatrick has made the motion. Do I have a second? The judge has seconded the motion. When I call on you, please state your vote. My vote is aye. Dr. Buffalino?
Aye.
Ms. Goldthwait?
Aye.
Ms. Roush?
Aye.
Ms. DeCastro?
Aye.
Dr. Marciano?
Aye.
Ms. Schmitz?
Aye.
Mr. Fitzpatrick?
Aye.
Judge Mazzarelli?
Aye.
Dr. Willie?
Aye.
At this point, if you are not a commission member or staff, you will be expelled from the virtual meeting. You will also be asked to leave the rooms, the two sites, and streaming will be paused. The stream will resume when executive session has ended. We will mute until this has been done and then continue on. We normally would have a break, but that ship has sailed earlier. So we're just going to power through, everyone. Thank you.
Okay, Jill, we are all set. We are now being recorded on WebEx and are also live on YouTube.
All right, thank you. All right, we are back in open session. No action was taken during executive session. Thank you all for your participation today. The next meeting of the Commission on Forensic Science will be December 15th. Do I have a motion to adjourn? Marciano has made the motion. Do I have a second?
Here.
Well, I guess we're just going to stay here.
I heard it. I think that was Bev who seconded. I was giving Albany a shout there.
Either one.
When When I call on you, please state your vote for the record. My vote is aye. Dr. Buffalino.
Aye.
Ms. Goldthwait.
Aye.
Ms. Roush.
Aye.
Ms. DeCastro.
Aye.
Dr. Marciano.
Aye.
Ms. Schmidt.
Aye.
Mr. Fitzpatrick.
Aye.
Judge Mazzarelli.
Aye.
Dr. Willie.
Aye.
Thank you, Superintendent. I see you there. I know you're there. I'm acknowledging your presence.
Thank you.
We are adjourned. Thank you.
Have a great day, everybody.
You too.
Good job.